searching for the right words. My level of confusion as to what both sides are doing and arguing is about pegged. Multiple times throughout multiple hearings, including on July 11th of 2024, Mr. Taylor and the defendant have emphatically stated this is not a battered spouse syndrome case. I've heard that multiple times, and I specifically pick the hearings we had on July 11th on other matters because it came up right at the end about the deposition of the expert. Mr. Ferris was coming up, and Ms. O'Donnell had said, I don't have a transcript, this is from my memory, Ms. O'Donnell had raised an objection that if Mr. Ferris was going to talk about, or he was a battered spouse syndrome expert, the required notice under the rule had not been given. And Mr. Taylor said again that this is not a battered spouse syndrome case. And so I left the courtroom on July 11th saying, okay, this is not a battered spouse syndrome case. We'll see what happens at the deposition. The very next day on June 12th at 4:33 p.m., the defense files notice of intent to rely upon battered spouse syndrome defense. And I looked at the notice of intent, and it complies with the rule. It gives the required notice. It talks about what evidence is going to be used to support the battered spouse syndrome defense. It provides the essential facts upon which the defense is going to rely. It provides a list of witnesses, including G. Bruce Eric Ferris, as witnesses who are going to support the battered spouse syndrome defense. And I don't recall if it was at that hearing or another hearing, we had a fairly in-depth discussion about the case law, including Oquendo and the differences between PTSD and reasonable person, and how battered spouse syndrome can be used in a stand your ground or a self-defense situation. But the emphasis was still, this is not a battered spouse case.
Judge, in fairness, I footnoted that.
In Hickson, I'm sorry, and so I'm confused there. On the state side, I've looked at the state's motion in limine to request a proffer of expert testimony. What I don't see in here is authority for that, where I can order the other side, you will give me a proffer of your witness's testimony for me to make a decision. I've made decisions based on a transcript that's been provided to me on discrete areas that may or may not be admissible. What this screams out to me, and I have no idea why we're not doing it, is a Daubert hearing. That certainly one side or the other can move for a pretrial ruling on the admissibility of scientific or technical evidence under 90.702 and the federal Daubert standard, where all of these issues, the qualifications of the expert, what they relied on, are those sources reliable? Did they apply reasonable and scientific methods? I mean, all the, I don't have the predicate in front of me, but that's where that hearing would be. Ask for a Daubert hearing, the other side needs to comply. So I don't consider today a Daubert hearing. This is just a straight motion in limine where I haven't heard from the expert I haven't heard anything. I don't have any facts in front of me about the Daubert factors or 90.702 factors. I haven't even been provided a copy of his transcript. So I don't know why we didn't do that. Next, my confusion is we discussed Hickson at a prior hearing, and it talks about as reflected in the rule, and I think, if I remember correctly, Hickson was a Florida Supreme Court decision that predated this rule and essentially laid out the framework of what eventually became Rule 3.201, I think it is, the battered spouse rule. And so Hickson kind of laid that out and fleshed out what then the Rules Committee turned into the actual rule that was then subsequently approved by the rulemaking process. And what Hickson talks about is if it's a battered spouse case, and the rule as well, and the expert interviews the defendant, then the state has every right to get its own expert to do its own evaluation of the defendant. Now, what I've heard is apparently Mr. Ferris, during his interview, or during his deposition, said he interviewed the defendant for several, and I'm just relying on representations now, I have not seen it with my own eyes, interviewed the defendant for several hours. There was some initial veracity or some initial interview. I don't know how long that was. But then there were 2 subsequent interviews after he was retained for this case. On the flip side, if the expert does not evaluate the defendant and is going to just speak about general, non-specific traits, which is what I've been hearing for the defense, it's going to be very general, it's going to be very non-specific. There was talk from the defense about there's going to be hypotheticals posed, but I will say that in the back of my mind, I was always wondering what those hypotheticals were going to be, if they were going to be very generic and non-specific, and then those hypotheticals started bringing in the facts of this case, how that would play out. But here nor there, that'll be a decision to be made later. But in this situation, what I'm hearing is the expert evaluated the defendant twice. And I only say this has nothing to do with my ruling on whether I'm going to order a proffer or not. It just goes to I want to just flesh out the issues of my confusion about, is this battered spouse? Is it not? What part of Hickson are we talking about? Is there been an evaluation? There's going to be hypotheticals and opinions expressed based upon the facts of this case? Or is this just going to be a very generic, he hasn't interviewed her, it's going to be a very generic discussion about domestic violence victims? We all know what brackish water is. I don't think Hickson allows for some kind of brackish presentation here. It's either battered spouse syndrome, and there was an evaluation, and the state has a right to do its own expert evaluation, or there was no evaluation, and it's purely generic information and hypotheticals. I say all of that with, just so you guys have the walking away knowledge of, we're less than a week from trial, and I am so confused. Is this a battered spouse syndrome case or not? I keep hearing it is. I keep hearing it isn't. I've heard everything I'm going to hear. I mean, I gave you both multiple opportunities to tell me. You just need to know. I still don't know where we're at. But my answer is this. I don't think there's any, I can't think of any provision under the law. I'm not aware of any authority under the rules that would allow me, and I haven't been provided any case law authority that gives me the discretion to say, defense, you will proffer your expert testimony. It's usually the opposite, right? That somebody wants to put something in, I have an objection, I rule it's out, and the defense or the state will proffer it so it's in the record. And of course, that proffer is, if you read the appellate court decisions on that, This is why it's so important for the proponent to get that proffer in, because it gives the trial court that opportunity to hear the evidence and hear the questions and hear the cross and make a ruling that avoids trial court error. So, with that lengthy explanation, the state's request for the court to order the defendant to provide a, there it is, proffer is denied.